Good afternoon, everybody. I, CNLU CARCIL, along with MOOT Sharma, will be serving as the court master for the final round of the 5th CNLU CARCIL National IBC MOOT Court Competition 2026. With the kind permission of the Honorable Bench, I shall briefly apprise the teams of the essential rules governing the final round. Each team is allotted 60 minutes in total, inclusive of rebuttals and sub-rebuttals. The division of time between the two speakers is at the discretion of the team, subject to a maximum of 35 minutes per speaker. The time taken for questions from the bench shall be included within the allotted time. Teams shall be identified only by the team codes. Any disclosure of the identity of the participants will attract penalties, including disqualification. Teams are not permitted to use any electronic device. If the expert assessors kindly permit, I request the speaker of the appellants and the respondent side to notify us of the time divisions. The appellant side.
These are 2 minutes.
Respondents. Thank you so much. I now request the appellants to begin with their submission. The council seeks permission to approach the dais.
Much obliged. Warm greetings of the day. Council seeks permission to collectively refer to the bench as the lordships. Much obliged. May it please the court, I am part of A113, appearing on behalf of the appellant in the present case of KCPL versus VLPL. Over the course of next 29 minutes, I will be arguing on issues 1 and 2, and my co-counsel will be dealing with issues 3 and 4. We would like to reserve 2 minutes for rebuttals. Dear Lordship, my submissions are twofold. First, I will establish that the present appeals are fully maintainable under Section 62 of the Insolvency and Bankruptcy Code 2016, as KCPL has the local standard to approach this code. Furthermore, the temporal compliance under Section 62 is fulfilled, and there exists substantial question of law in this present case. Secondly, I will demonstrate that the COC acted beyond the statutory power in entertaining an unsolicited EOI after finalization of the final list of prospective resolution applicants, Your Lordship, which are in direct contravention of the CIRP regulations. I will thus conclude by submitting that these violations strike at the core of procedural certainty and fairness envisioned under the IBC. If Your Lordships have no other preliminary questions, I would like to proceed with my first issue. Much obliged, Your Lordships. Your Lordships, I believe that this issue goes to the heart, not only the fate of an appeal, but the fate of access to justice itself. For if this appeal is held non-maintainable, the law shuts its door before it hears the grievance, Your Lordships. Your Lordship, in this light, my submissions are threefold. First, we submit that the present appeals are undoubtedly maintainable under Section 62 of the IBC, founded upon three critical pillars. The applicant's locus standi to approach this court, strict compliance with the temporal framework.
Counsel, what is the question of law here? Come to that.
Your Lordship, I will be.
Can you answer the question first? What is the question of law?
Lordship, if you may refer to. Just a second, Your Lordship. If Your Lordship may please refer to para 9 of the 10 submissions, page 17. If Your Lordships are with me. Yes. The Constitution Bench judgment in Sir Chunilal V. Mehta laid down
Let's not go to the precedents. What is the question of law in this case?
Your Lordship, we raised three substantial questions of law in this present case. I'll give you in brief and I'll be dealing with it in detail later. Firstly, that the COC ignored mandatory provisions of the CIRP regulations and took decisions beyond the code and the regulations of CIRP. Secondly, whether the findings of Section 66 can retrospectively applied to render a resolution applicant ineligible under Section 29A. And thirdly, we'll submit whether the fraudulent or wrongful trading under Section 66 can be presumed in absence of mens rea and strict proof, Your Lordship. If you're satisfied, I may continue with my first issues. Much obliged, Your Lordship. Your Lordship, if we may note the plain language of Section 62, which says that an appeal to Supreme Court contains three crucial elements, Your Lordship. Firstly, that any person aggrieved by an order of the NCLAT may approach the Supreme Court on a question of law within 45 days. Your Lordship, these three essentials have been clearly fulfilled in our present case. Your Lordship, the expression any person aggrieved carries a wide connotation and is not confined merely to parties directly engaged in the litigation, but extends to those whose substantive rights have been violated and affected by the order. Your Lordship, in the case of Independent Sugar Corporation versus Garib Shriram Janeja, the court held that the party whose plan should have been accepted, as in the present case, if it had not been for the erroneous judgment of the NCLT, qualify as an aggrieved person under Section 62 and have the locus standi to approach this honorable court. Therefore, Your Lordship, the applicant undoubtedly qualifies as an aggrieved person under Section 62.
If we assume for a minute that you are an aggrieved person,
Yes, Your Lordship.
we still, on the face of it, believe that there might be mixed questions of fact and law here. And as a Supreme Court, we can't go into those issues. So why do you think, and as you know, Supreme Court essentially will test the judgment of the NCLT and not reopen the whole factual matrix. So why should we interfere in this matter, considering that there is a dispute regarding the facts?
Your Lordship, I will be proving in my further issue that they are not reappreciation of fact. The respondents make a content that we are asking for the reappreciation of fact.
Can you give me a skeleton of that argument right now? Very, very briefly in 2 sentences.
Like I mentioned, the three sub-points that we are contending, which are the substantial question of law. If you would just let me complete the temporal compliance, I might come to the substantial question of law. Much obliged, Your Lordship. The second essential of Section 62 is the temporal compliance. The NCLT order came on 6th June 2025, and this present appeal under 62 was filed on 6th July 2025, well within the 45-day limit of Section 62. Your Lordship, now I come to your question.
Counsel, you mentioned about the INSCO judgment. What about, this is the judgment in the context, what was the question of law involved in INSCO?
Your Lordship, I'm currently unaware.
No, you referred to this because you wanted to define what does the person aggrieved means.
Yes, Your Lordship.
Has the Supreme Court dealt with that particular question in this judgment?
Yes, Lordship, as far as I remember, no.
So then how do you define?
Sorry.
No, please continue. Please continue.
Your Lordship, in this judgment, the court held that an aggrieved person under 62 is somebody. So the resolution plan of the applicant was rejected in this present case. However, the court held that the resolution plan of that person whose plan should have been accepted stands as a person aggrieved. The facts are very similar to our present case. KCBL's
It's very different from your case. The question of law involved in that judgment was in the context of approval of Competition Commission of India, whether that is a prerequisite for a plan to be put to vote. That's a completely different question of law. Are you aware about last trust judgment of Supreme Court? Okay, so then you answer to this bench. How are you a person aggrieved? How should this court look at it? How should we interpret the person? You are a person aggrieved because a resolution applicant does not have a vested right until and unless it is approved by it. That's a position of law, right? So how are you a person aggrieved? Why should we hear you today?
Yes, Your Lordship. Your Lordship, KCPL in this case submitted its formal on the deadline, submitted an EOI. Was on the final resolution applicant, the only one on the final list, Your Lordship.
Okay, can you answer this? Do you have a vested right to be heard with respect to your particular resolution plan? Do you have a vested right?
Your Lordship, if I may
The
just
Committee of Creditors has not approved. Be mindful of the fact that the committee has not approved your resolution plan. For whatever reason, they've approved some other plan, right?
Your
If I
Lordship,
may take this question forward, if we were to agree with you on this appeal, what is it that you eventually, what sort of directions would you want from us, assuming that you succeed?
Your Lordship, it has been mentioned in our prayer what we want. If you want, I can read the prayer to you.
No, you can tell me. I can read myself. I know how to read.
Let's keep it conversation based. I think we are trying to have a conversation. We want to understand what is it that why you are here before us today.
Your Lordship, first of all, we want that the entire judgment that rendered us ineligible shall.
I think you need to answer Abhishek's question as my question.
Yes, Your Lordship. I'm answering.
Whether you have a vested right and also why this needs to be considered.
Your Lordship, we have a vested right to approach this court. Our substantive rights have been affected in this present case. Your Lordship, first point I want to bring to this bench is that.
What do you mean by vested right?
Your Lordship, us by participating in the CIRB became a party to that process. We followed all regulations and became a legitimate.
What prejudice would be caused to you if your plan is not approved?
Your Lordship, ultimately all the parties in this CIRB process want that the company does not go into liquidation and the best possible plan is taken. Your Lordship, the erroneous judgment of NCLT took away our right to further participate into the section 29A eligibility. Also prohibit us to further participate in any insolvency process, Your Lordship. So also section 29A says that the eligibility of the resolution plan shall be done on on the date of submission, Your Lordship. It has also been reiterated in the case of Haribabu Tota. Your Lordship, if you may refer to page 39, para 115 of the written
Haribabu
submission.
Tota deals with entire 29A or it deals with a particular clause of 29?
Your Lordship, if I will take a moment.
Yes.
If I may just take a document. Thank you, Your Lordship.
Take your time.
Sorry, Your Lordships. Apologies for that. Your Lordship, if you may pardon my question.
Haribabu Tota deals with the entire 29A or it deals only with a particular clause of 29A?
Your Lordship, it deals with 29AC.
Yes.
And
Read 29AC.
yes, Your Lordship. Your Lordship, 29AC says at the time of submission of the resolution plan.
Are you hit by 29AC?
Your Lordship, we are contending that in the present case, the I will come to that also in my further arguments, that the Section 66 order of the NCLT cannot be retrospectively applied in the present case. As Section 29A and Haribabu Tota reiterates that the eligibility shall be checked on the date of submission of the resolution plan.
For which clause?
Lordship.
For which clause of 29A Haribabu Tota says that?
29 AC, Your Lordship.
Does 29AC apply to you?
Yes, Your Lord.
Which particular clause of 29A is applicable in the facts and circumstances of the present case?
Lordship, clauses 29A, G and J of the applies to our present.
Now read G.
Yes, Lord. 29AG has been a promoter or in the management or
We start with the preface, the first line of 29A and then go to G.
Apologies. Person not eligible to be a resolution applicant, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person who has been a promoter or in the management or control of a corporate debtor in which a preferential transaction, undervalued transaction, extraordinary credit transaction or fraudulent transaction has been taking place and in respect of which an order has been made by the A under this act.
Would a judgment interpreting 29AC of this code would also apply to 29AG?
If I may continue.
Yes.
That's not the correct submission, counsel. The Haribabu Tota judgment is in the context of 29AC, which refers to SR Steel, right? Which is like my brother judge just mentioned. That was in the context of 29AC's applicability, which is not relevant in your case. So we are not satisfied on the fact that whether or not it will, we don't even want to go to the prospective argument because preliminarily, at least you've not satisfied us on this question. It appears that because of your disqualification on account of an order from the NCLT, you continue to remain disqualified during the process also.
Your Lordship, if you allow, my co-counsel will deal with it in very detail. If I may proceed, Your Lordship.
Yes.
Much obliged. Your Lordship, coming to the essential, most crucial essential of section 62. There is a substantial question of law right. As given in para 9, page 17 of our written submission, which laid down, Sir Chunilal B. Mehta laid down the controlling test, Your Lordship. That a substantial, if Your Lordships are with me,
Yes.
a substantial question of law is one in which is of general public importance or which directly and substantially affect the rights of the party and has not been settled by this court. Your Lordship, in the present case, we humbly submit that the IBC proceeding affect creditors at large, resolution applicants, third-party investors, and market confidence.
Under section 62, do you actually need a substantial question of law?
Your Lordship, we need a question of law.
What would be the difference between substantial question of law and question of law?
Your Lordship, question of law is a broader phase, while substantial question of law is a narrower phase, where substantial question of law are questions that affect the right of the parties, is of public importance, as I already mentioned in the controlling test by Chunilal B. Mehta. So section 62 requires a very substantial question of law for this Supreme Court to appreciate an appeal under section 62.
It requires substantial question of law or it requires only question of law? What is the requirement under 62? Look at the provision. Yes.
Your Lordship, it lays down question of law.
Can you tell us any one judgment of this court where 62 has been interpreted and we have laid down the parameters of what does it mean by question of law?
Your Lordship, I'm trying. Apologies, Your Lordship. Your Lordship, thus we humbly submit that the present appeals satisfy this test on multiple grounds, raising grave and questions of law across three distinct dimensions, Your Lordship. Firstly, whether a question of law arises as to whether the COC under the guise of commercial wisdom can depart from mandatory, statutory and regulative prescriptions, Your Lordship. Your Lordship, this is not a mere factual appreciation of commercial decision. Rather, it concerns the jurisdictional discipline and regulatory compliance by the COC itself.
Your Lordship, Regulation 36A 6 clearly states that the expression of interest received after the time specified in the invitation shall be rejected. Your Lordship, the use of the word shall by the legislative framers make it a mandatory provision. The COC has been given discretion, however, not in matters where the provisions of the statutes have been made mandatory, Your Lordship.
Have you made COC a party here?
Your Lordship, yes, Your
Are
Lordship.
they a respondent here? Okay. Now, a COC has a commercial wisdom to decide on it. At the time when your plan was rejected, they had a plan and expression of interest in place. Why should we stop the COC from exercising? Because there was no other plan.
Your Lordship, first of all, the commercial wisdom of the COC, even though it has been held to be paramount, shall be done firstly within the timelines described in the IBC, and secondly, should adhere to statutory mandate.
Is it mandatory for the COC to comply with 36A6?
Your Lordship, if I be present the case. Your Lordship, if you may refer to page 28, para 66 of the written submissions. Your Lordship, Your Lordship, it is submitted that the court held that in the name of shelter of maximization of value in commercial wisdom, RP and COC.
No, Counsel, you're not answering the question that I've asked. The question is very simple. Is this provision mandatory or is it directory?
Your Lordship, it is mandatory.
Is there a judgment which says so?
Yes, Your Lordship. Your Lordship, if you may refer to page 25, para 49. Your Lordship, this court held that as 36A6 and 39(1)(b) that the committee of creditors shall not consider any resolution plan received from a person who does not appear in the final list. The COC was not empowered to consider the applicant's resolution plan.
I hope you are mindful that we are the Supreme Court. We are not. You're citing a judgment of the NCLT, right?
Yes,
Is it binding upon us?
It is a persuasive value. It's a very landmark of judgment.
Was it carried to the Supreme Court?
No, Your Lordship. If I may proceed, Your Lordship. Your Lordship, so the first question.
Sorry to interrupt, but I have one more question. Come to page 44 of your prayer. You are seeking direction to the committee. The only direction that I can see, at least, to the COC is to consider your plan submitted in accordance with law. Now, is it okay that we send both the plans back to the COC, ask them to consider, and then whichever they think in their commercial wisdom they will approve?
Your Lordship,
I think we can close the matter with that, because the COC can consider both the plans, and whichever they think is the best plan in their commercial wisdom, then they can approve the same.
Lordship, however, IUL's EOI did not come within the deadline of the EOI. So, of the Form G, Your Lordship.
We think that is directory in nature, not mandatory. COC can still consider in their commercial wisdom, because you have placed an NCLAT judgment before us. We have a different view from what NCLAT has said.
Your Lordship, if that may be the case, the applicants respectfully submit that the Form G shall be reissued, and then both the parties shall be allowed to submit a resolution plan.
But it's a time-bound process. There is already a substantial delay. Why would we want to issue the Form G again? If you are so confident, because your prayer is only to consider your resolution plan. You're not asking for issuance of new Form G.
Your Lordship, because we contend that, we pray for that, because the KCPL's plan was within all deadlines, followed all the mandatory provisions that were provided to the KCPL. So the KCPL's plan at the end of the closure of the EOI for Form G was the only eligible plan. IUS EOI came after the deadline, did not follow the due process, Your Lordship.
It's very convenient how you are arguing that your disqualification is prospective but not retrospective, but IUS EOI because it came belated. So it's like it's a convenience-based interpretation of law.
Your Lordship, timelines are the very core of the IBC.
Exactly. So we want to send both the plans back to the COC and let the COC consider.
Your Lordship, however, still contend that only KCPL's resolution plan shall be.
How do you deal with clause 3 of the RFRP?
If I can.
Clause 2 and 3 of the RFRP.
Your Lordship, if we read clause 2 of the RFRP, it allows the COC to engage with resolution plan at any stage.
Yes.
However, again, Regulation 39(1)B does not allow submission of any resolution plan beyond the limit. Your Lordship, as if you
Read
come
clause 4.
nothing contained shall be constituted as obligating the COC to limit its instruction and negotiate. Yes, Your Lordship. However, if you may come to section subclass 5 of the RFRP, in the event any provision of this RFRP is found to be inconsistent or in contravention with the IBC or any rule or regulations, such provisions shall stand severed from the RFRP. Your Lordship, both these clauses directly violate the regulations of CIRP. These shall be held severed and void from the RFRP. Your Lordship.
Council, have you raised objection to these clauses earlier, that these are inconsistent?
Yes, Your Lordship, we are.
You have access to RFRP since the time it was given to you, right? Were the objections related to these clauses being illegal raised earlier? Or is it conveniently being raised right now?
Your Lordship, that has not been mentioned in the MOOT proposition. And
But you participated in a time-bound manner.
Yeah.
That has been mentioned
Under the same RFRP.
under the same.
Your Lordship, if I may be the one.
So put differently, is it open to you to participate in a process? And having failed in that process, subsequently challenge the RFRP or its provisions?
Your Lordship, we can challenge the RFRP as they are in contravention with the regulations and rules of the.
So if the RFRP is bad and the RFRP, we strike down the RFRP, then the ensuing process will also be struck down. So you don't stand at an advantage over anyone because the entire process is gone. So your right to submit a resolution plan in terms of this process is also then gone. Then we may send it back and ask the resolution professional to rerun the entire CIRP from inception. Give everybody an opportunity. Would you be fine with that?
Yes, Your Lordship, in the present case, due process was not followed while taking the IUL's EOI. So if, in arguendo, if that may be the decision of the court.
How do you deal with clause 1? Read clause 1. Of the RFRP.
Yes, Your Lordship. However, Section 29A also mentions that the ineligibility shall be checked at the date of submission of the resolution plan.
It does not, but let us assume that 29A mentions that. Can COC not add another disqualification which is over and above 29A?
Your Lordship, I will be coming to that in my second issue. That
The second issue is already started. We don't have time.
Yes, Your Lordship.
Yes.
I'll briefly tell you about it. Your Lordship, the COC's commercial wisdom operates within statutory bounds and cannot contravene express legislative mandates. Your Lordship, it is humbly submitted that the Honorable High Court held that the expression shall be completed in section 12 is used. The process shall be completed in 180 days. Furthermore, if you read paragraph 65 of the written submission, page 28, Your Lordship, if Your Lordships are with me, paragraph 26 mentions a fair reading of the above provisions, particularly the one underlined, indicates that the regulations do not permit the proposals to be entertained which are not in the final list of PRAs, and the adjudicating body has acted as per these provisions.
No, we are on your disqualification. How do you deal with clause 1? Suppose you are not disqualified under 29A. Read clause 1 of the RFRP. By way of this clause, you have been disqualified. What's wrong in this clause?
Your Lordship, however, the MOOT problem says that we have been rendered ineligible under Section 29A by the means of order of the entered under Section 66.
Let us read which paragraph we.
Yes, Your Lordship. Your Lordship, if you may refer to para 5 of the MOOT proposition. If Your Lordships are with me.
Yes.
Your Lordship, the second last line. In the light of this, the COC deferred voting, citing that Section 66 order constitutes a disqualification under Section 29A of the Act.
But we don't want to go into 29A. You are also disqualified by clause 1.
Your Lordship, however, the MOOT problem clearly states that we were disqualified under Section 29A and not clause 1 of the RFRP, Your Lordship.
But clause 1 of the RFRP is also in the MOOT problem.
Yes, Your Lordship.
How do you deal with clause 1 of the RFRP?
Your Lordship, it
Let us
says,
assume that under 29A you are not disqualified. How do you deal with this?
Your Lordship, the wording of the RFRP clause 1 says that becomes subject to any disqualification under the applicable law. Your Lordship, the applicable law is IBC. As you just said, what if we are not disqualified under Section 29A? Then what clauses disqualifies us, renders us ineligible, Your Lordship? Your Lordship is satisfied? Yes. Much obliged.
Counsel, since you have 1 minute, you want to summarily put into 3 points what are the submissions that you want to make?
Yes, Your Lordship. I'll just briefly conclude issue 1 and briefly deal with issue 2, Your Lordship. Your Lordship, the second and third substantial question of law that we raise in this question is that the retrospective application of this order under 29A and that the fraudulent trading under Section 66, under which we were disqualified, did not prove requisite mens rea, was purely based on hindsight and basis of suspicion. Therefore, I conclude my first issue and says that we have the local standard to approach this court on substantial question of law. Your Lordship, if you may allow me to briefly tell you the issue 2. Your Lordship, the issue 2 is based on 5 cumulative. Your Lordship, I would like the counsel seeks permission for an extension of 2 minutes to summarize.
Go ahead.
Your Lordship, the second issue, it is the cumulative effect of 5 critical factors. Firstly, the mandatory nature of Regulation 36A and 39(1)(b), which were clearly violated by the COC in the guise of commercial wisdom, Your Lordship. Secondly, there's the time-bound essence of the application, Your Lordship. How the taking into consideration of late EOI, not following the CRP regulations and deadlines, divorce this principle. Thirdly, the conclusive finality of the final list of PRAs, Your Lordship. Thirdly, the impermissibility of RFRP clauses overriding statutory mandate, as mentioned in clause 5 of the RFRP. And lastly, the nature of COC's commercial wisdom, that it operates within statutory bounds and legislative mandates, Your Lordship. If Your Lordships are satisfied, I would like to raise my submissions and issues. Thank you, Your Lordship. It was an honor arguing for this.
The council seeks permission to approach the case. The council seeks permission to address the bench collectively as your lordships. This is co-counsel on behalf of the applicants, and I will be dealing with issue 3 and 4 for a total time of 5 minutes, wherein
issue 3 deals with that the registered sale deed does not constitute a transaction.
We have the, I think you've conserved time and please start with your arguments on issue 3.
Much obliged, Your Lordship. For establishing what actually Section 66 means, I directly lead you to the essentials of Section 66. Kindly refer to page 31, para 80 of the written submissions. If Your Lordships are with me. You see,
What para again?
page 31, para 80.
80. Right.
In this, they have listed 3 essentials that are required for satisfaction of 66 herein. First being carrying of business, second being intention to defraud, and third being that any person who is knowingly a party to carrying on business with the intention to defraud. Your Lordship, with this framework in mind, I'll be dealing with this issue, with this submission in a 2-pronged approach. Firstly, that the intention of defraud is not present in this case, and secondly, that ACPL was not knowingly a party on carrying on the business in the present case. Your Lordship, to move with the first sub-issue,
There are 2 subsections in 66.
yes, Your Lordship.
Which subsection would apply to this case?
Your Lordship, Section 66 has basically 2 subsections. First deals with fraudulent trading, and second deals with wrongful trading. In this present case, the section for fraudulent trading applies as per.
Do you have 66?
Yes, Your Lordship. If I may read that to you, how it applies.
Yes.
Yes, Your Lordship. Section 66, fraudulent trading or wrongful trading.
Yes.
Clause 1. If during the CIRP or liquidation process, it is found that any business of corporate debtor has been carried out with the intent to defraud creditors of the corporate debtor or for any fraudulent purpose, the adjudicating authority may, on the application of the resolution professional, pass an order that the person who were knowingly party to carrying on the business of the in such a manner shall be liable to make such contributions to the assets of the corporate debtor as it may be paid. Lordship, this section deals with this clause deals with fraudulent trading. Now the next clause, which involves only the director and persons who are in control of the company, deals with wrongful trading, and it requires basically 2 essentials that is for wrongful trading. Firstly, that they were aware that there is impending insolvency, that insolvency might commence at any time, and secondly, they did not do any willful due diligence to minimizing the potential damage. Lordship, this is not a case of wrongful trading according to the opposite party. It is a case of fraudulent trading. And to prove that fraudulent trading even does not apply in the present case, because to include us, that is KCPL, in the proceedings, they need to Section 66(2) cannot be applied, as it only deals with persons in management and control of the corporate debtor. If your lordships are satisfied, the council
Come to the transaction audit report in your moot proposition.
Yes.
See paragraph 4, background.
Yes, Your Lordship.
Just read out paragraph 4.
In the year 2023, VLPL started defaulting in repayment of loan, and consequently, Bank of Bharatvarsh declared the account of VLPL as non-performing
Now
asset.
come to it, paragraph C1. The registered sale deed is of 5th April
5th
20.
April 2020.
So in 2023, there was a default, right? You did your diligence at the time of acquisition of the property.
Your Lordship,
This is a critical asset of the company. This was sold. So did you do your due diligence?
yes, Your Lordship, we did our due diligence, but we are not aware of this financial stress. We did not
How
have
can-
any.
How can you not have any? If you have done your diligence, how can you not know?
Your Lordship,
No, if you had done your financial diligence, you would have seen the financing documents which would require lender approval, etc. Did you check that?
Your Lordship, we entered into sale transaction of land. We did
That's
not
fine, but
enter
this was a
into the-
secured. Was it a secured asset?
Land for them wasn't secured asset that was presented.
Is it mentioned in the fact sheet?
It is not mentioned.
Going with the presumption that this is a general pool of assets of the corporate debtor, it would be secured in favor of the lender. In such a case, while doing your diligence, did you not see whether or not there are any third-party approvals required, or under what will be the utilization of the proceeds? All of that check was done or no?
Your Lordship, what BLPL did was they just lawfully discharged of a legal liability that they had.
Why did you agree to pay this to a third-party entity which was a director of the company, knowing fully well that this company was in default?
Your Lordship, you are not aware that this company was in default.
It's mentioned in the fact sheet.
Your Lordship,
Which means if you're saying that you were not aware that this company is in default, it means that you've not done your diligence.
Your Lordship, it is not mentioned in the fact sheet. It is a mere presumption on the part of
Was the land mortgaged or not mortgaged?
uh, the land was not mortgaged. It was unencumbered, and there was no bank loan on the land. If your Lordships are satisfied, coming to the question.
Which para says that it was not encumbered?
Your Lordship, Executive Summary Clause 2 says that upon the review of the sale, noted that the requisite stamp duty has been paid, and the consideration recorded therein was slightly above the prevailing market rate. We also observed that records that said that the said land was unencumbered and carried with no subsisting land charge. If your Lordships are satisfied. Now coming to the question your Lordship posed, that in the present case, we did do our due diligence and it was a legal transaction we entered into. As I've already stated to my Lordship that in the present case, all the legal compliances were met, and Indian Contract Act does not restrict such a transaction in which I enter into agreement with one party, and for that I pay to other party that is required by the contract that we entered into, and it is not disallowed by Contract Act in any way. Moreover, this lawful discharge was done at a point of time. Firstly, I'll give you to the background of what the loan was. Lordship, in 2020, this company was facing financial stress, and Arun Valmira in the same year came up and gave them 4.5 crore of unsecured loan without any collateral, my Lordship. This was a bona fide loan that Mr. Arun Valmira gave to them during their financial stress. Lordship, what BLPL did was in 2023, it said that it was a bona fide loan paid towards this discharge its legal liability to pay off the loan, and it did not pay the whole amount of loan. It paid 2 crores of loan to us.
So your best argument is that even Mr. Valmira was a creditor.
Yes, your Lordship. Even
When
Mr.
the company is in stress, can you pay a creditor to the exclusion of other creditors?
And wouldn't that make this a preferential transaction then?
Your Lordship, this does not amount to preferential transaction, and it is not that we were not paying the loan to Bank of Bharatvarsh till 2023.
Why would it not be a preferential transaction?
Your Lordship, it would not be a preferential transaction because we did not show any preference towards KCPL. It was a transaction which had a roadmap that I'll establish that I am BLPL. I want to sell my land, which is of 2 crores, and what I want to do is legally discharge my liability that I owe to Mr. Arun Valmira.
You're defending for VLPL,
No, I'm defending for KCPL.
but you just said that you were lawfully discharging one loan. But how did you come to know that the secured creditor will have priority? Are you aware about 53 waterfall?
Yes.
So will secured creditor not rank in priority to the unsecured creditor?
Yes.
And how are you justifying the conduct of VLPL and saying that it was lawful discharge of an existing loan?
Your Lordship,
Is Bob loan not a lawful loan, so to say?
Your Lordship, it is a lawful loan and it was taken in 2011, and we have been paying that loan for more than 12, 13
We have been paying, again you are defending for VLPL.
VLPL has been paying that loan, and
That itself shows, counsel, you're defending VLPL and defending KCPL. It looks off.
Your Lordship, I am just trying to establish that what VLPL did and what we are doing.
Is there a VLPL counsel here?
Your Lordship.
So they can submit their case separately. You submit for KCPL. You're saying that this was a discharge of an unsecured loan in priority to a secured creditor, and you're saying that that's not a preference. It's clear case of a preference transaction here.
Your Lordship, even if it is said that it is a case of even if your lordship say that it is a case of preferential transaction, it is not a case of fraud. That is what I am contending.
But it doesn't help you because even preferential transaction will disqualify you.
Your lordship,
We might agree with you that the NCLT and NCLAT erred in holding that this is a fraudulent transaction. But you need to satisfy us that it is not a preferential transaction.
your lordship, to satisfy you on that regard, the related party aspect that makes it a
How do you determine preference? Which section of the IBC deals with preferential transaction?
Your lordship, section 43 of the IBC deals with preferential transaction.
Is there a mechanism to determine preference?
Yes, your lordship, as far as I gather, I have 4 essentials that are there. Firstly,
Read 43(2)(b).
The council does not have 43 to be regard. (43)(2)(b). The transfer under clause A has the effect of putting such creditor or surety or guarantor in a beneficial position that it would have been in the event of a distribution of assets being made in accordance with section 53. Your lordship,
So is BOB a secured creditor?
your lordship, BOB is a secured creditor.
Is it written in the MOOT proposition that BOB is a secured creditor?
It is not written in the proposition, but the council does have the definition of secured creditor. And BOB is within that.
No, are there facts indicative of BOB being a secured creditor in the MOOT proposition?
Yes, your lordship, it was entered into with a contract, and they also had to pay interest on that loan. And in the fact sheet, it is given that about the loan that
Why don't you read paragraph 2 of the background?
yes,
Of the TAR?
paragraph 2. In year 2011, Bank of Bharat extended a working capital term loan of rupees 143 crore to BNPL, which was secured by way of mortgage of 40 crore. So it was a secured loan which 48 was backed as collateral. Shall I proceed?
Or Mr. Valmera a secured creditor?
Mr. Valmira was not a secured creditor.
So are you not hit by 43(2)(b)?
Your lordship, Mr. Valmira was
Because you have been continuously saying that there are no facts to indicate that we were not paying BOB. But would you have paid even a penny to Mr. Valmera until and unless the entire debt of BOB were repaid?
Your lordship, but we did not, in that say, we did not directly give money to Mr. Arun Valmira. We made a sale deed wherein KCPL transferred it to them when he, in bona fide condition, gave
So
us.
you are representing KCPL, right?
Yes, your lordship.
So you are not we here.
Yes, your lordship.
Yeah.
So, your lordship, KCPL did not know that this was a transaction which would put Mr. Arun Valmira in such a state.
You
We
may
did
not be
have any
correct.
intention or
You may not be correct in saying that the consideration was not paid to Mr. Valmera, because para 2 of the problem states that the consideration was paid to him.
yes, your lordship, the consideration was paid to him, but KCPL did not know of such a transaction. KCPL, it was something that DLPL did, and it was their contract that we entered into. They put up that clause in the agreement that we will give you this part of land, and we want to give you, and we want you to give the consideration to Mr. Arun Valmira. We were not aware of such preferential transaction. Therefore, we say that we do not owe any liability because we were not aware of such transaction. Your Lordship.
Yeah, please proceed.
If your Lordship is satisfied.
Are you a related party to BLPL?
Yes, your Lordship, because of section 5.
How are you related?
Your Lordship, Mr. Varun Malmera who is the 25% shareholder of KCPL, is the brother of Mr. Varun Malmera.
Then on the day of submission of the resolution plan, were you not hit by 29A J read with 29A C?
Your Lordship, I again contend that the bar that is present is on the date of submission of resolution plan. It is given in the statute itself.
On the date, you were not a related party. On the date of submission of the
We
plan.
were a related party, but Section 29A is a blanket bar which is to be construed strictly. Now, to read Section 29A to your Lordship,
J read with C. Does that make you a disqualified person?
your Lordship,
29A J read with C. You are saying you are a related party, you accept that. So the account was rendered NPA in 2023. You were aware of it on the date of submission of the resolution plan. NPA account makes a related party of the promoter also ineligible under 29A, right? So in any case, you are ineligible.
no, your Lordship, we are an MSME. Section 240A states that MSME cannot be disqualified under Section 29AC. If your Lordships are satisfied with that, I read the pretext to clause G and J, which states that a person shall not be eligible to submit a resolution plan. Your Lordship, submission date already passed on 24th, and this disqualification that we incurred was the 26th of February, your Lordship. So this blanket bar,
Which disqualification? Section 66 disqualification.
Section 66 order that disqualified us came on 26th Feb. Therefore, we realize that from interpretation of the statute itself, and even in the case of Mr. Haribabu Tota, RCL himself, these all state that the section start with a person shall not be eligible to submit a resolution plan. After submission, it is a different context. Therefore, I say that the bar, that is 29A, was not legally applied to KCPL. And moreover, KCPL, even though it is a related party, your Lordship, the IBC does not punish related party just because it is a related party. There should be intention.
But I'm asking the same question. How do you deal with clause A of the RFR?
Yes, your Lordship, to deal with clause A of the RFRP, your Lordship, this matter is now also sub judice before the court. It is not decided that we are ineligible, that we were.
It has been decided.
Your Lordship, it was decided by NCLT NCLAT, but now we are again sub judice because it is before the Supreme Court of India.
You are ineligible till we decide otherwise.
Your Lordship, to prove how Lordship, the council seeks 30 seconds to gather his thoughts. Your Lordship, even Your Lordship, this clause says that disqualification should be under applicable law. Now, the applicable law in this case is IBC, and disqualification has been itself specifically being mentioned in
No,
the
you
IBC.
are not arguing that 29A does not apply to you. You are saying that 29A will not apply to you because your plan has already been submitted. After submission of plan, you are ineligible under 29A. Your argument was that a person will be ineligible to submit a plan. That is what 29A says. So date of submission of the plan is the deciding factor. Now read clause 1 of the RFRP.
Subject
Even
to,
if we give you that benefit of interpretation of section 29A, that 29A will apply only at the date of submission of the plan, the fact remains that otherwise you are ineligible under 29A. And read clause 1 of the RFRP.
Subject to the provisions of IBC,
Yes.
if it is determined at any stage that
At any stage. So clause 1 says at any stage.
your
Your
lordship,
argument under 29A is that you determine the ineligibility at the as on the date of the submission. But clause 1 allows the COC to see your eligibility at any stage. How do you deal with that clause?
your lordship, if you are going with strict interpretation, then the first line itself states subject to the provisions of IBC. The provisions of IBC itself say that this,
What do you mean by subject to provision of IBC?
that what parameters IBC prescribe.
Can COC not prescribe an additional condition which is over and above 29A?
Your lordship, this
29A would say, according to you, and we are not with you on that, but 29A, if you go by your submission, says that it will be decided on the date of submission of the plan. Can COC not put another clause in their RFRP saying that we will determine it at any stage of the process?
your,
How is it in contravention with the provision of the code?
your lordship, for this I'll take you to a report of BLRC,
Yes.
which is cited in page 38, para 110 of our written submission.
Let us see.
If your lordships are with me.
Yes.
Your lordship, the Bankruptcy Law Reforms Committee expressly cautioned against equating every instance of default with malfeasance, observing that such an approach is a characteristic of a weak insolvency regime. Your lordship, the committee emphasized that the indiscriminate exclusion of participants, which would be done if such blanket would be included by every COC in every case, if this is allowed in the present
You know
case.
that this committee did not come up with 29A.
Yes, your lordship, it did not come up with.
Will BLRC reports apply to interpretation of 29A?
Your lordship, it will apply to the interpretation of IBC because it deals with bankruptcy law, and therefore on that context, if we see this report, it says that the logic behind this report is not every disqualification like this cannot be triggered mechanically or on just any inference alone. And this inference has again been drawn on a standard of proof which is the TAR report. Now, if your lordship are satisfied,
Counsel, I don't think we're satisfied, but just to add, let's take your interpretation for a moment. Open 29A.
yes, your lordship.
What is the first disqualification? If somebody is an undischarged insolvent, they are not permitted to submit a resolution plan. In your case, let's take the director. There is a personal insolvency proceeding initiated against him during CIP. He's not an undischarged insolvency. He goes into bankruptcy. Discharge order is not yet passed. Okay, can he submit a resolution plan at the time of whenever the date of submission of plan arrives? Are you saying he's eligible to submit?
Your lordship, in the present case, if you are talking about Mr. Arun Valmira, he's already an undischarged insolvent before.
No, I'm saying, let's play it out sequentially. In this case, if he is insolvent, right? At the time of submission of plan, he's an insolvent or he's not an insolvent at the time of submission. Subsequently, he becomes insolvent. Are you saying that subsequently he can continue to participate in the process? Is that what 29A is all about?
Your lordship, from the strict interpretation of this.
No, first of all, I don't see a preface where it says that 29A starts at the time of submission of plan. It's only in 29AC. But if you're saying, taking your interpretation for a moment, let's play in this situation. Are you saying Mr. Valmira can participate in the process if during the process he's insolvent?
Your lordship, the council begs to differ because it is
No, you've not answered. How can you differ?
on the point that it is only given in section 29AC because the pretext also reads the same.
So tell me, please show me. I'm very curious to know now.
Your lordship, before all the clauses,
Mhm.
it is said that the heading of this section is person not eligible to be a resolution applicant.
Okay.
Wherein, after this, it is given that a person shall not be eligible to submit a resolution plan. So this, from its interpretation,
When is it not? Okay, I will test it on the date of submission of the plan. But if during the process, if somebody becomes insolvent, should I allow them to continue to be participant in the process? Are you saying that 29A eligibility is only on X day? From X day till the date of approval, he can be disqualified, but that's fine. Is that the interpretation? Can that be considered in this case?
And is it even logical? And what is the objective behind 29A?
Your Lordship, the objective behind 29 is to remove any defaulter or someone who has malfeasance against.
Correct.
In the past, done malfeasance against the corporate data.
That's right. So if a person who's become disqualified from submitting a resolution plan after the process was initiated, if such a person is allowed to continue with the plan, wouldn't that violate the sentiment of the section itself?
Your Lordship, that's why we firstly argue that we were not someone who was liable to pay under section 66 of the IBC.
Even in that case. So even in taking your example factually, you're saying that the order came in subsequently. But for what period does it pertain to? When did you, hypothetically, keeping aside that hypothetically assuming that there was a fraud, when did that fraud happen?
Your Lordship, the alleged fraud took place in
2023. This was before CIRP.
Yes, Your Lordship.
So it was before plan submission. Therefore, the determination pertains to the period prior to the submission of the plan.
No, Your Lordship, because if we read clause G, which has been contended in the present case, it has been said that only after an order by the adjudicating authority. Therefore, the order is the threshold to determine this.
But when that order should come in?
Your Lordship,
So it seems like somebody can go scot-free. There can be a preference order against them during CIRP and they should be permitted to participate. Have you read the statement of objects and reasons of, because there's a lot of jurisprudence that you've cited. Have you read the statement of objects and reasons of 29A? What does it say? Do you have it?
the council does have it. Can I take it out? Yes, Your Lordship. Referring to the statement of objector reasons, the particular para you are referring to, if I may, should I read that to you? Concerns have been raised that persons who, with their misconduct, contributed to the defaults of the companies or otherwise undesirable may misuse this situation due to lack of prohibition or restrictions to participate in the resolution or liquidation process and gain or regain control of the corporate.
Yeah, I think this is the first part that we can refer to. So somebody who has contributed to the default, has caused the company to go into insolvency, should not be permitted to participate at any stage.
Especially in this case, because there was a possibility that your client would have been barred under 29AG in respect of a different transaction. That is not the case here. It's not as if you are running, a separate entity. You've actually been barred under 29AG in this very case. So there is a preferential transaction, a fraudulent transaction in this company itself, which makes it worse.
Your Lordship, this fraudulent transaction, the KCPL was not aware of this fraudulent transaction. We plead ignorance to the fact that we were unaware that Mr. Arun Valmera or the corporate debtor was leading to such a fraudulent transaction. Therefore, we are innocent and we only want to submit a resolution plan and participate in this CRP process because we want the betterment of the corporate debtor, that is DLPL. We are not a party who wants to, the council seeks permission for an extension of limits to answer the question. Therefore, we were not aware, and if you read the TAR report, the material evidence that was produced therein that NCLT and NCLAT saw was not conclusive in any way. Your Lordship, if I may read clause 6 and 7 of the TAR report to you to determine how this is not material evidence. Your Lordship, kindly refer to the last second page of the MOOT problem. If Your Lordships are with me. Your Lordships, in this report, it is given that based on the timing and relationship between the parties. So the two factors that are timing and relationship, it appears that both Mr. Arun Valmira and KCPL may have been aware of impending financial stress and structure the transaction in a manner whereby the sale consideration was directed to Mr. Arun Valmira. Now, reading the next clause, when we read from the second line, the direct routing of consideration to him gives rise to an impression that the sale deal dated 5th April 2023 may require scrutiny as a potential fraudulent transaction. Your Lordship, this is not a conclusive proof. And to prove a fraudulent transaction, you need a conclusive proof, and as also held in various judgments. If I may cite some
No, but
judgments.
the entity carrying out the transaction audit is not obligated to prove the burden of a transaction. The eventual decision on whether it is a preferential transaction or a fraudulent transaction can only be taken by the NCLT. The auditor can only carry out an audit, prepare a report, and submit it for consideration, which is what they have done. And the NCLT finally applied its mind and accepted this report.
Your Lordship, that is what we contend, that NCLT and NCLAT were both aired in taking the threshold of evidence required in Section 66 applications as a low one, because this is merely suspicion and inference that is drawn.
No, but for that you are assuming that the NCLT's decision is based solely on this report. The transaction itself was before the NCLT, as was this report. And the NCLT, in its wisdom, thought that this report is accurate. And they probably examined other factors as well. What leads you? So let me frame this as a question. What leads you to believe that the NCLT's finding on the fraudulent transaction was based solely on this report?
Your Lordship, because the only piece of evidence that was admitted by the RP was this report. If we see how RP
The transaction are the evidence. This report is just an expert opinion. We look into the transaction. How do you explain the transaction that has happened?
Your Lordship, the transaction that has happened, to prove that it is a fraudulent transaction, firstly we require high level of proof, which is not just mere suspicion. It should have material facts attached to it. So this transaction, for the part of timing, that they have cited two material things to say that it is a fraudulent transaction: timing and relationship. Lordship, for timing, it is held in an NCLT case that mere temporal closeness to NPA declaration does not lead to a fraudulent transaction per se. And secondly, relationship. Lordship, the code punishes fraud. It does not punish relationship. Just because Mr. Varun Valmira was also a related party in the present case does not mean that he was involved in such fraudulent transaction.
I think you are more of a counsel of the corporate editor and a director than KCPL.
Are you saying that Mr. Arun Valmera is disqualified under G and you are not? Is that what your submission
Yes,
is?
Your Lordship.
So you are related party to Arun Valmera, and J read with G would make you disqualified even when you are an MSME?
Your Lordship, we say that we do not have any control, or we do not have any intent for Section 66 order.
But Arun Valmera had,
Arun Valmira was
might have had
this.
So if Arun Valmera is disqualified under G read with J would make you also disqualified, being a related party.
Your Lordship, in that case,
Even when you directly did not have the intention to do fraud, even if it is attributed to Arun Valmera as such, he becomes disqualified under G. And G read with J would make you also disqualified. There's no exemption for MSME for this.
Your Lordship, even if we were a connected person, which I contend that we were not, because a related party is also to have some kind of control over the affairs of corporate debtor and some kind of collusion with them. We did not have any collusion for this particular transaction. if you're
You're a related party and you paid the consideration to him instead of the company. You did not challenge the payment of consideration to him. To us, it seems like when you put all the facts together, it is very clear that you are as guilty as Mr. Valmera.
Your Lordship, it is just based on mere inference. It is not an substantial evidence per se to determine even the Section 66 criteria or to bar for Section 29.
And the fact that you paid him more than the market price of this property also points at collusion. Why did you pay him more than the market price?
Your Lordship, it was slightly more than the market value. The market value was 1.95 crores. We paid 2 crores, and it was only because of the contractual terms that were we entered into. If your Lordships, just may I'll summarize my issues.
But whether related party transaction allows,
Sorry, pardon, Your Lordship.
whether related party transaction guidelines allow such transaction?
Your Lordship, the council is not aware of the related party guidelines. If you may point out the particular,
That's under Companies Act.
the council is not aware of the same. If your Lordships have any other substantial, the council will conclude both the issues and will move on with the prayers.
We've read the prayers.
It was an honor arguing with you.
Thank you.
Council seeks permission to approach the dais. Council seeks permission
We
to
start with the first issue.
agreed, my lords. Before council proceeds with the arguments, if the council may furnish a copy of the compendium of
Yes.
case laws to the respondents as well as to the bench.
Sir.
Appellants, finally, lords. Apologies. My lords, with respect to the present matter, before council delves into the maintainability arguments under issue 1, if the council may draw the attention of the court to the fact that the cause title of the present suit is KCPL versus VLPL along with IUEL, my lords, and that the appellants in the present matter have not impleaded IUEL to the present suit. So the council would just like to draw that to the cognizance of the court and then proceed with.
It's their appeal. They can make whoever they want to.
Indeed, your ladyship. However, much obliged, your ladyship.
No, sorry, you complete the sentence.
Now, with respect to them not impleading IUEL, any such prayers that they have put forth before this honorable court will not have an adverse effect on our client, your ladyship. Proceeding with arguments for issue 1, that is whether this appeal under section 62 brought before this honorable court today can be allowed or not. My lords, it is very simple and
Can be allowed or is maintainable.
maintainable or not.
That's the first threshold. Allow we come to later.
This indeed, my lords. With respect to that, if a bare reading of the section 62 in itself would lead us to 2 specific phrases, my lords. That is any aggrieved persons and a question of law. Now, any aggrieved person refers to who can approach this honorable court under 62, and any question of law arising from an
Sorry, Council, who are you representing?
IUEL as well as so we are representing Valmera Lifestyles Private Limited as well as IUEL.
Valmera through the resolution professional.
Indeed, your leadership.
And you're representing
IUEL, who is the successful resolution applicant in the present matter.
RP and the successful resolution, both you're representing.
Indeed, your leadership.
Are you not conflicted?
Indeed, not your leadership.
How come?
Considering the fact that